Welcome everyone to lecture number 28.5. Okay, so till now we have discussed till article 15. Okay, now we are proceeding to learn about article number 16. What exactly is present within that article 16? Okay, so article 15, within the article 15 we have covered most of the aspects, every aspect, so not most, all the aspects we have covered within the article 15. Okay, among with the 103rd constitutional amendment that was done in 2019 by the Modi government when they want to introduce economic reservation for the economical weaker section by 10%. So regarding that, there were two amendments that were done. One amendment was added in the constitution by adding a article 15 clause 6, and another amendment was done by adding article 16 clause 6. Okay, that was done during that time. Okay, now we'll see article 16 clause 6. Article 16 clause 6. Yeah, sorry, article 16, what I am telling, article 16, will see what this article 16 tells us. Okay, it gives us equality of opportunity. It gives us equality of opportunity in matter of public employment, in the matter of public employment. Okay, so article 16 guarantees, it guarantees equality of opportunity in matters of public employment, in matters of public employment. Okay, that is the overall theme of it. Okay, so what are the aspects that is present within the article 16? What does it tell? So it says that there shall be equality of opportunity for all citizens in matter relating to the employment or appointment to any officer under this state. Okay, so all the citizens of India will get the equal opportunity. It won't be like that the people from that caste, from that community will not get equal opportunity, will not be eligible for this job. Okay, that won't be the case. So all the people will get equal opportunity for any matters relating to the employment or appointment for the officer under the state. Okay, and mark that point, when I'm telling that it is employment, so it is only the employment, not with respect to the promotions. Okay, so let us suppose there is a provision of reservations. What exactly is that? We'll see that. We have seen in article 15 also. Okay, that guarantees that a special provision government can make where the reservation can be provided, that state shall not discriminate against any citizen on ground of only of religion, race, sex, caste, marriage, but there is some exceptions on it where they can do for uplift the social strata, the people who are present on the lower level of the social strata. So government can provide a reservation to such people so that they will come uplift within the society. Okay, so article 16 provide equal opportunity for those people. So let us suppose reservation is there. So if a person from a lower strata has been appointed on the basis of reservation for any particular office, so now once it has been appointed, after that the person merit will be required for increase within that job. So let us suppose after next year there will be a appraisal, there will be a promotions that will be going to happen. So the person cannot claim on the basis of reservation that I am from that caste, so I will need a reservation on that. No, that won't be possible. Promotion will be solely based upon the merit. Okay, it is not telling about promotion, is nowhere mentioned, but I'm telling you with the perspective of the exam, with the perspective of the interview questions and all. Okay, so the article 16 guarantees us with respect to the matter of employment. Okay, when the reservation part will come, then we'll see what are the things that we can do. Okay, so it tells about the public employment. Okay, equal opportunity will be given. Okay, so now there shall be equality of opportunity. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state, to any office under the state. Okay, and no citizen shall on the ground only for religion, no citizen, I'm just giving overview. So what is article 16, clause 1, clause 2, clause 3, clause 4, clause 5, clause 6, we'll discuss it. Okay, I'm just giving overview of it currently. Okay, so no citizen shall on ground only of religion, race, caste, sex, descent, place of birth, or any of them be ineligible for any employment, okay, on the basis of race, sex, caste, descent, place of birth, or any of them, they won't be declared ineligible for any employment under the state. Okay, under the state. Understood? So this was a glimpse of it, what was actually present within the article 16. Okay, and there was 77 amendment was provided to continue the reservation and promotion of the SC and ST, and identification of backward classes subject to the judicial review, that was mentioned. Okay, so now we'll dig more deeper into article 16. What exactly is that? So we have understood that article 16 is related to the employment opportunity, that all the section of the society will get equal opportunity with respect to the employment. Okay, with respect to the employment. Now we'll see what exactly is article 16 clause 1. Okay, article 16 clause 1 tells that there shall be equality. There, one second, I want to mark it here, that I have mentioned that public employment. What does it public employment mean? Public employment means government jobs. Okay, public employment. Okay, so article 16 clause 1 tells that there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any government, any office under the state. Okay, so whatever the things that I have mentioned it here as a point, that will be our article 16 clause 1. Okay, now article 16 clause 2, what it tells? No citizen shall on ground only on religion, race, caste, sex, descent, place of birth, residence, or any of them we'll add a place of birth, that is residence, any of them be ineligible for or discrimination against in respect of any employment or the office under the state. Okay, so what are the things that we discussed it here? That will be our article 16 clause 2. Okay, now whatever the things that we have told here, now on the where discrimination can't be done. Okay, no discrimination can be done on the basis of as per the statement 16 clause 2. But now discrimination, now we'll see how discrimination can be done. Okay, so on the basis of domicile can discrimination be done. Okay, and it is not mentioned, it is not mentioned anywhere. Supreme Court also said up to 50% of the seats can be made reserved on the basis of domicile reservation. Okay, so domicile reservation can be made. Okay, and Supreme Court has also sanctioned this, that up to 50% of the seat can be made reserved on the basis of domicile reservation. Okay, for any state that you if required any job, so domicile was asked that to enjoy the benefit of your, let us suppose I am from the state of Bihar, so in that case if I want to pursue in the Bihar government job, so I will be getting, I have my home within the state of Bihar, I am from the Bihar state, so I will be having a domicile of a state. Okay, as I when I am discussing the citizenship, that I have a citizenship of the India, and India have only singular citizenship, it does not enjoy the dual citizenship. So when I have explained, I have mentioned that we have a single citizenship, but we can have a domicile. Okay, domicile means that you will that is a part that will symbolize that you are from that state. Okay, now when I have a domicile of a state of Bihar, so when I will be applying for the job in the state of Bihar, I can I will be using the 50% reservation, because 50% if whatever the cap is fixed by the Bihar government, the maximum cap is 50%, that has been fixed by the Supreme Court. So whatever the reservation has been fixed by the Bihar government, I can opt for that. Okay, on the basis of domicile. Okay, understood? Now what exactly is Article 16 clause 3? Article 16 clause 3. Article 16 clause 3 confers or provide the power on the parliament to provide by law residence as a qualification in cases of certain classes of employment under the state. Okay, it confers to, okay, let me write it. It confers or provide, it confers or provide the power. What kind of power? Power on the parliament to provide by what? By law or by residence, as a qualification, that you can give a qualification as a residence, that if I am telling that I am from a state of Bihar, that can be act as a qualification for me. Okay, so as per the Article 16 clause 3, that it gives the power to the parliament, if it gives the power to the parliament that they can make a law on the basis of the residence that can act as a qualification. In what cases? I can't do that. I can I haven't done a BTech and I will be acting as an engineer. Why I will be telling myself as an engineer? Because I am from the state of Odisha or a state of Gujarat. Okay, no, that won't be the case. If you are an engineer, you must have a BTech degree or whatever the required degrees for that. Okay, so yes, qualification residence can be make a qualification, but there are cases for it. Okay, what will be the cases? As a qualification in cases of certain classes of employment, in certain, that have to be defined by the government, that in such class of jobs residence can be made as a qualification. Okay, classes of employment under the state. I will give you example for it. Let us suppose you are from a state of Andhra Pradesh. Okay, and you know Telangana. Now Andhra Pradesh people are coming to Delhi or north region to as a tourist. Okay, as a tourist they want to visit Taj Mahal in the Agra, or Red Fort in the Delhi. Okay, so they want to visit such places, but they don't understand, many of them, let us suppose they don't understand Hindi, and even though they don't understand English. So in what case, in that cases we'll have a translator by the tourist by the government tourist agencies and all. Okay, now for the translator, so there can be a residence as a qualification. Let us suppose there is a translator who will tell that I am from Andhra Pradesh, I know Telugu, and I can easily explain within the Telugu to them, and I can easily translate within the Hindi also, English also, if more people are there. Okay, so in that case, in such cases, qualification residence can be made as a qualification for them. Okay, so there was a rule in Andhra Pradesh called Mulk rules. Okay, and there was bulk of group C and group D was reserved for the people of Andhra Pradesh. So Parliament said residence can be made as a qualification for the group C and D post. Okay, so that is one of the examples. So yes, residence can be made as a qualification for the ground of the employment as per the Article 16 clause 3. Okay, it is Parliament alone that prescribes such conditions. So who can provide such conditions? It is not that alone that a state government will decide. It is the Parliament who will decide such conditions. Okay, that too in regard to the state and not to the union appointment. Parliament cannot make a decision for this employment as a qualification for the union aspects. Okay, this will be whatever the decision that Parliament is going to make or law is going to be passed, that will be only with respect to a particular state. It won't be a union appointment. Okay, yeah. So in 1974, now whatever the laws that is Article 16 clause 3 tells, in 1974 whatever the laws were made, after that it was lapsed. So in 1974 those laws which were made by the Parliament was lapsed. Okay, now Article 16 clause 4. Okay, we'll discuss about that, what exactly Article 16 clause 4 tells. So in the Article 16 clause 4 empowers the state to reserve seats in the favor of backward classes, SC and ST, in public employment, provided these classes are not adequately represented in the services under the state. Now it is very important. Now it becomes very important, this law. Okay, so it empowers the state, to reserve seats in favor of backward classes, that is SC and ST included, in public employment. Okay, if any particular section is not adequately represented within the public employment, then there can be a reservation of seats for them, okay, in public employment, provided these classes are not adequately represented in the services under the state, okay, under the state. So yes, okay. Regarding one point I want to mention, in the article 16 clause 3, there is only Andhra Pradesh and Telangana which is falling, which is using this article, uh, where the qualification on the basis of residence is made, okay. That point I missed, I just want to note it here, okay. So yes, so article 16 clause 4, that it empowers the state to reserve the seats for the backward classes including SC and ST in the public employment, provided that it must be provided that they are not adequately represented within the service and the state. So let us suppose if I want to tomorrow, I am going to tell that a particular let us suppose I am going to tell that Muslim people need reservation in particular offices, okay. So you must have a proper data to prove that Muslim people are lacking in these services, and that's why we need a reservation for the Muslim people, okay. So that's, you have to prove that adequate representation should be there. Yes, they are actually not getting benefit, and they are not being appointment, they are lacking behind that. So they are not, there is not equal representation of such people from that society within that particular service on in the job. So we'll provide reservation for them. So in that case only that reservation will be provided. So Supreme Court in Indra Sani versus Union of India case, let me mention it, the spelling is little bit twist. So Indra Sahani versus Union of India case, okay, that was happened in 1992, that is famously known as Mandal case, okay. So what happened under this, it classified the legal principle relating to the reservation, okay. So article 16 clause 4 is an enabling clause, that means no reservation without 16 clause 4. So now this article 16 clause 4 is what? It is a enabling clause, that it must be verified, only that reservation will be provided. That no reservation, it means no reservation without article 16 clause 4. There won't be any reservation without article 16 clause 4, okay. Now second point, any reservation policy in the favor of backward classes shall have to satisfy 5 constitutional requirements to the Supreme Court, okay. That was given by the Supreme Court, that if is there any reservation, if any reservation policy, let me give you that reservation policy in favor of backward classes shall have to satisfy 5 constitutional requirements. What are those requirements? We'll see. They have to fulfill the first constitutional requirement to the Supreme Court. Okay. Then they must have to fulfill. Whenever the case goes to the Supreme Court, then they have to satisfy these 5 requirements. What are the 5 requirements? First, social and educational backwardness, that is, a state has to provide to Supreme Court. Okay, that a state has to provide to the Supreme Court who are these backward people. Okay, it means that government has to provide the data to the court. Like, suppose there are 100 posts in a government job, then they have to provide that 60 seats are taken by the upper caste and then lower caste are discriminated. Okay, that data has to be provided. So social and educational backwardness that is, it means that a state has to provide to Supreme Court who are these backward people. First, they have to mention to the Supreme Court who are these backward people, to whom we are talking about. That people who are from the tribal society or people from that region, from this region, are the backward people. Okay, who are these people? So we have to first identify that who are these backward people to whom that we want to provide a reservation. Okay, so first we have to state, we have to identify, we have to prove that who are these backward people to whom that we government want to give a reservation. That government has to prove that. Okay, now second important point, the backward classes in the opinion of the state are not adequately represented in the public employment. Okay, so the backward class in the opinion of the state are not adequately represented in the public employment. Okay, so it means, what does this statement means? What does it, if a government tell this thing, okay, this section of the people are not adequately represented within the public employment, so we'll give the representation. The Supreme Court will ask the proof. Okay, give us the proof that whatever you are telling is correct. Okay, it means, this means, it means government has to provide the data to the court. Government has to provide the data to the court. Okay, like suppose if I give you example, there are 100 posts. Okay, there are 100 posts in the in any government job section. Okay, there are 100 posts. Okay, within the 100 posts, 60 are taken by the upper caste people. Okay, and 40 is being taken by the lower caste people. Okay, now if we see 60 is greater than 40, so upper caste people are capturing more position in the government job than compared to the lower caste people. So that kind of data that government has to provide to the Supreme Court and we have to satisfy to the Supreme Court that yes, lower section of the people are not getting adequate representation within the public employment, so we want to give a reservation to them. Okay, So as per the article 16 clause 4, we can this is the enabling clause, and to give a reservation we have to satisfy 5 points. Among the 5 points, first is like, in first we have to identify who are these people. In the second, we have to prove that these section of the people who are identified as a backward people are not being adequately represented within the public employment. Okay, understood? Now article the third important point, the concept of creamy layer. The concept of creamy layer shall apply to the OBCs. Okay, it will be applied to the OBCs. What exactly is this creamy layers? We'll see. Okay, and this creamy layer concept, is not applied for SC and ST. This creamy layer concept is not applied for SC and ST. This creamy layer concept is only applied for the OBCs. Okay, and who are these OBCs? So within the OBC, let us, the threshold has to be defined. Okay, a threshold need to be defined. Okay, so let us suppose like if people is earning more than 6 lakh rupees, so that OBC will be counted under the creamy layer, and if people is earning less than 6 lakh rupees, that will not come under the creamy layer, and they will get the reservation for the OBCs. Okay, so a threshold will be defined, what amount of money, annual income of the family should be there. So on that basis they will be deciding on the creamy layer who are those people will fall under the creamy layer, and who are those people who are not falling under the creamy layer. The people who are falling under the creamy layer for the OBCs will not get the reservation. Okay, understood? Yeah. So the reservation cannot at any point, now the very important point, reservation cannot at any point exceed 50%. It can't go more than 50%. That's what, when the economical weaker section was being implemented, so it was going above the 50%. So now it was told that the reservation that is being given, it is not basis on the caste. Okay, it is not going on the basis on the caste, and they amended the constitution within the article 15 clause 6 and article 16 clause 6 to provide the reservation for the weaker section. Okay, so now on the top of that, economical weaker section was awarded as the 10% reservation. The overall, and one more thing important is that the overall efficiency, should not be affected, as required under article 335 subjective clause. Okay, so if you are administrative efficiency will not be challenged, then go ahead. Okay, so what it tries to say, what are the terms and conditions? First, that we have to identify who are those people to whom you want to give the reservation. Second, you have to prove, the state has to prove that those people who we have identified are not adequately represented. Okay, so we have to give a proof to them, like we have to provide a data to the Supreme Court. The third, the concept of creamy layer will be applied to the OBCs, like there will be a threshold that will be defined, that let us suppose within the OBCs whose annual income is greater than 6 lakh rupees, they will not come under the reservation, they will fall under the creamy layer, and they will not be provided any reservation. That kind of concept will be provided for the OBCs, and this concept of creamy layer will be applied only to the OBCs, not to the SC and ST. Okay, reservation at any point should not go to the greater than the 50%. And now the amendment was provided for the EWS weaker section, where the 10% cap was 10% reservation was provided to them through the 103rd constitutional amendment that was done in the year 2019 by the Modi government. Okay, and further, very important aspect, that the overall efficiency of the office should not be compromised. That should not be compromised. Okay, so Indra Sani case. So within the article, so in within the Indra Sani case, so the power conferred by the Article 16 Clause 4 enables the state to provide reservation only at the entry level. That was provided only at the entry level. It is a enabling clause. Okay, no reservation will be provided without Article 16. So through the Indrasani case, it was proved, it was concluded that Article 16 will be considered as the entry level reservation. Okay, and no reservation will be provided on the promotion. Okay, so only at the time of recruitment, this reservation will be applicable. This is an entry level reservation as per the Article 16, and no promotion will be given on the basis of this Article 16 or on the basis of any reservation. Okay, reservation is only provided for the recruitment at the entry level, not on the promotions. Okay, the reservation based on economic backward among the general criteria is no criteria to extend reservation. So constitution only talks about the social and educational backwardness. Okay, so but we will be seeing that economical weaker section will be provided. Okay, so as per the Indra Sani case, it was mentioned that the reservation based on economic backwardness among the general criteria is no criteria to extend reservation. From the Indra Sani case, that was concluded that they were against the economical backwardness. Okay, what is the verdict that was given? Okay, but we'll see that that amendment was done in the 103rd amendment, that economical weaker section will be on the basis of economy we can give a reservation. Okay, in Tamil Nadu, reservation percentage is 69%. In Tamil Nadu, if we see, reservation percentage is 69%, because they convince the Supreme Court, that is the proportion to the social backwardness of the population, we need reservation to balance it. Okay, so in Tamil Nadu there is a 69% reservation, and they were successfully able to convince the Supreme Court that we have to exceed the percentage level of the 50% to adequately represent the population. Okay, so yes, there are exceptional cases that Tamil Nadu is having a reservation more than 50%, that is 69%. Okay, so Article 16 Clause 4A, Article 16, what exactly is Article 16 Clause 4A? We'll see. Article 16 Clause 4 subclause A. Okay, so the Parliament decide to amend the Constitution inserted by the 77th Constitutional Amendment Act. So 77th Constitutional Amendment Act happened in 1995. Okay, what was that? Reservation in promotion for the Supreme Court, in the SC and STs in public employment will be there if, in the opinion of the state members of these communities, are not adequately represented in the public employment. Okay, so now they added. So now the 77th Constitutional Amendment was provided that we can give the reservation in the promotion also. Okay, that what we are telling, that the reservation on the basis of promotion was not applied as per the Indra Sani case. So now to implement that case, to provide the reservation on the basis of promotion also, the government came up with the constitutional amendment, 77th Constitutional Amendment, that now will provide the reservation on the basis of promotion also. So though added in the Constitution, Article 16 Clause 4A, that reservation in promotion of SCs and STs in public, SCs and STs in the public employment will be there if in the opinion if in the opinion of the state members of these communities are not adequately represented in public employment. So they have to prove to this Supreme Court whenever they are giving a reservation in the promotion also, then they have to prove and provide with the adequate data they are not being adequately represented in the public employment. Then in the case of promotion also they will be given a reservation. Okay, see, this is a bizarre situation. So as the amendment has been done, it was not provided in the original constitution, and the amendment was done as per the requirement. So now there was no rule for the reservation. Article 16 was concluded as the entry level for the reservation point. Now they amended the Article 16 by adding a clause 4A that now in the promotion also will give the reservation for the SC and STs in the public employment. With the data they have to provide that they are not being adequately represented in the public employment on the basis of promotion also. Okay, so M. Nagaraj versus Union of India 2000 case has happened. Within that case, 3 constitutional requirement was there. The SC and ST communities are socially and educationally backward. Supreme Court asked to provide the data in the M. Nagarajan versus Union of India. So within that case, that happened in 2006. So in that case, it happened that that was a requirement that they mentioned that SC and ST are not adequately represented in the society in the education. Supreme Court said that provide us the data for it, provide us the required data for it. Okay, they provided the data, but they are not adequately represented in the public appointment. Okay, and it does not affect the efficiency in the administration, that it should not affect the Article 335. So they have to compete those things. Okay, so these were the important aspects that were provided. So within the M. Nagarajan versus Union of India, 3 constitutional requirement came up that SC and STs are not socially backward, so we have to provide the data for it, provide the data that they are not adequately represented in the public employment, and third, we have to prove that it is not compromising efficiency in the administration. Okay, in that case only we will give the reservation to it. So in UP state power corporation, in UP state power corporation versus Rajesh Kumar 2012 case, within that thing UP government failed to provide quantifiable data. After that they tried to amend the constitution. UPA government, SC and ST deemed to be a backward, but not passed in the parliament. So okay, so when this case went to the Supreme Court, they failed in providing a quantifiable data for it. So thus that was not added as a reservation for them. Then they tried to amend the constitution also when the UPA government was there. So in that case also it was not passed in the parliament at that time. Okay, now there is a concept of horizontal reservation also. Okay, what exactly is the horizontal reservation? We'll see. Article 16 clause 5 is also there, and clause 6 is also there. We'll see. First, moving ahead, we'll see what exactly is horizontal reservation. When a particle group into various subgroup are called horizontal reservation. Okay, so within the let us suppose within the OBCs we are telling that there are section 1, there are section 2. So this will be horizontal reservation, and when we are telling that OBC, SC, ST, that will be our vertical reservation. Okay, so let me give you, I'm confusing you. Okay, so this is OBC, let me do it in the, then there is SC, ST, then OBC, then general. Okay, so these are vertical strata thing. Okay, in that basis reservation will be vertically. Okay, let's suppose not general, we'll add EWS. Okay, now what is horizontal reservation? Within the OBC we'll tell that there are section 1, there are section 2. Okay, so this will be our horizontal strata division. Okay, so Supreme Court said that horizontal reservation is valid provided that classification is done at a reasonable basis. So if you are doing a horizontal reservation also, then you have to provide a adequate data for it, and provide that that the reservation is correct, only that you have to prove that thing to the Supreme Court, then only it can be provided. Andhra Pradesh provided reservation within Andhra Pradesh provided reservation that the 27% reservation will be there, 4% within the 27% reservation is present. Within the 27% reservation for the OBCs, 4% reservation will be given to the Muslims religion. Okay, so T. Maralidas Rao versus state of Andhra Pradesh, that happened, that is given on the basis of religion is going to be given on the basis of. So like within the Andhra Pradesh 27% reservation is OBC, we know that. Okay, within that 27% they said that 4% reservation will be given to the Muslim son. Okay, Muslim. So now this reservation is on the basis of religion. Okay, so this will be challenged in the Supreme Court. Okay, now when this was challenged within the Supreme Court, so Andhra Pradesh said that we are not providing reservation to the Muslim, we are providing reservation to the socially and educationally backward Muslims. This is not only Muslim, these Muslims are socially and educationally backward Muslims. They are not Muslims, they are socially and educationally backward Muslims. And Supreme Court agreed on this. Supreme Court and agreed on this, and they give nod to it. Okay, so then 27% within the 27% reservation for the OBCs, 4% reservation is for the Muslims. Okay, understood? Yeah. Now this we have seen that Article 16 clause 4A, that reservation in the SC and ST in public employment in the opinion of state members are not adequately represented, then we can do a reservation for it as per the Article 16 clause 4 clause A. Okay, now there is Article 16 clause 4 clause B is also there. When A is there, then B will also be there. So Article 16 clause 4 B, what it tells, that carry forward of the seats can happen. Okay, let us suppose there is 100 seat. Okay, within the 100 seat, 50 is reserved and 50 is for general. Okay, it is for general, and this 50 is for reserved. Okay, now within the 50, let us suppose 40 seats were filled and 10 seats became vacant. Okay, 10 seats become vacant. Now this 10 seat can be used for the next year reservation. Okay, you can carry forward this reservation. Carry forward policy came as per the Article 16 clause 4B. It came through the 81st Constitutional Amendment Act that was done in the year 2000. Okay, that was done in the year. It came, this article for Article 16 for clause 4 clause B come with the year, come with the amendment 81st Constitutional Amendment 2000. Okay, now what will happen then when there is now this concept of carry forward comes? So let us suppose now 10 seat is vacant. Okay, now what will happen in the next year? Now we are going to next year. What will happen in next year? Total number of seats will be 110. Okay, and 50 seats will be given for the reservation, 50 seats will be given for the general category, and now the extra 10 seats will be given for the reservation also. So now the next year reservation will be total number of reserved seats will be 60, and total number of seats reserved seats will be 60, and total number of general seats will be 50. So this carry forward policy implemented was directed through the Article 16 clause 4 clause B, subclause B. Okay, now Article 16 clause 5. What exactly is this Article 16 clause 5? We'll see. Article 16 clause 5 tells that nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connecting with the affairs of any religious or denomination, institute, or any member of governing body thereof shall be a person, profession, or a particular religion or belonging to a particular denomination. What exactly that? I will explain you in detail. Let me write it, then you will understand word by word. When you read it, then you will be able to understand it. Okay, so nothing in this article shall affect the operation of any law. Nothing in this article shall affect the operation of any law which provides what it provides, which provides that the incumbent of an office in connection, those office, that operation of any office in connection, which kind of office? Whose affair with the affair of any religious or denomination, institute of or any member. So it is talking about that nothing in this article is hindering such offices. Which offices? Those such offices which deals with the religious activity or any kind of denomination, institute, like related to religious activity, or let us suppose that organization is there that deals with the poor people, or that NGOs kind of things. Okay, so those offices, denomination office, or any member of governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. What does this mean? It is telling that, simply it is telling that, let us suppose a temple is there. In the temple, it is a very big temple, Balaji, let us suppose temples are there. Lots of people, thousands of people used to go every day now, and thousands of people give some money, in the charity box of the temple and all. Okay, so now for the administrative purpose of, there should be administration, there will be office of that temple. Okay, now for the now the person who is going to run such offices, now the temple can decide that only Hindu can present in the office, and they can only work within that offices. Okay, so that kind of profession, that kind of if they are decided that such offices should be filled by those community only. Let us suppose Muslim also have built some such offices, and they are telling that we will hire only Muslim to such offices, so nobody is going to stop you. That power is given through the Article 16 clause 5. What this Article 16 clause 5 tells us? This Article 16 clause 5 tells that nothing in the article shall affect the operation of any law. It is not hindering any law which provides the incumbent of an office, working on an office, in connection with affairs of any religion, any office which deals with the religious activity or any such denomination. So this article is not affecting them on their work. Okay, and further there shall be a person, they can appoint a person on the basis of profession, they can appoint any person professionally on the basis of his religion, they can appoint such person on the basis of a religion. If his person is Hindu, I can yes, a temple is allowed to take that person professionally. They can make a professionally a religion as a qualification for that person, that only Hindu will be able to work in our offices. Okay, they can do so. So they that is allowed for a person professionally from a particular religion or belonging to a particular denomination. Okay, so that is allowed. So temple will be created by a particular office headed or employed by Hindus only. Yes, it can do. Like Ram Mandir is building currently, so that will be built by the only Hindu. That will be by the only Hindu labor. Okay, yes, they can do so. It is upon them. Yes, they can obviously do so. Okay, so this is power is given through the Article 16 clause 5. And now through the Article 16 clause 6, it allows the state to make a special provision for the reservation of up to 10% appointment post in the favor of EWS in the service under the state. Okay, so through Article 16 clause 6, we get the power for the reservation of such people who are in economical weaker section, or 10% reservation can be provided. Even there is a cap of 15%, 50% cap is there for the reservation. So yes, on the top of it, 10% reservation can also be provided as a special provision for the economical weaker section of the society. Okay, so that was all about in the Article 16 lecture. Okay, so we'll see Article 17 in the coming session. Thank you. Please like and subscribe this channel. We are new. We need your support. Thank you.